Exam Scholar, Real Estate Edition.
Question 1. Which of the following cannot be defined as escrow monies? A. Promissory notes. B. Security deposits. C. Personal bonds. D. Earnest money. Answer. C. Personal bonds cannot be used as escrow money because the escrow money must be immediately available in most cases. Any of the other answers listed are acceptable for escrow monies. Question 2. Which of these are considered a protected class under the Fair Housing Amendments Act of 1988? A. A dog. B. A child. C. An immigrant. D. A single mother. Answer. B. Of the listed choices, the presence of children in a family were added to the Fair Housing Amendments Act of 1988. Question 3. Ben, the landlord, wishes to charge Betty extra rent because she has a child living with her. This would be considered A. Legal. B. Illegal. C. Legal in certain neighborhoods. D. None of these. Answer. B. This practice is illegal according to the Fair Housing Amendments Act of 1988 that included the presence of children in a family as a protected class. Question 4. Building heights, setbacks, and density are usually established by A. Local building inspectors. B. Zoning regulations. C. County ordinances. D. State general plans. Answer. B. Zoning regulations control the use of land as well as determine building heights, setbacks, and density. Question 5. What does the Real Estate Settlements Procedures Act cover? A. Residential mortgage loans. B. 1 to 4 family mortgage loans. C. Commercial mortgage loans. D. Installment mortgages. Answer. B. Also known as RESPA, the Real Estate Settlements Procedures Act covers 1 to 4 family mortgage loans, including equity loans. Question 6. Careful zoning can have which effect on property values? A. No change in property value. B. Increased property value. C. Decrease in property value. D. None of these. Answer. B. Proper and careful zoning can increase property values by means of the principle of conformity. Question 7. If Jerry sold his land to Margaret, he could inhibit Margaret's future enjoyment of the property by what means? A. Nothing. Once the property is sold, it belongs to Margaret to do as she pleases. B. Through zoning laws. C. Through deed restrictions. D. Through court order. Answer. C. Deed restrictions are restrictive covenants on the use of the property that run with the land. Question 8. Abel has the right to cross through Peter's property to get to his property. What is this right called? A. A license. B. An appurtenant easement. C. A habendum clause. D. A contract. Answer. B. Abel has an appurtenant easement that allows him to cross over Peter's property to get to his own. Question 9. If Nancy owns the property that Heather crosses over to get to her own property, Nancy owns which parcel? A. Dominant. B. Neutral. C. Subservient. D. Servient. Answer. A. Because Nancy owns the land that Heather has to cross over by easement to get to her property, Nancy is said to have the dominant parcel. Question 10. In order to bind a contract between two parties, consideration must be A. Money. B. Goods or services. C. Money, goods, or services. D. Anything the parties agree upon is valuable enough. Answer: D. Consideration in a contract can be anything agreed upon between two parties that they consider to be valuable enough to satisfy the contract. Question 1. Land is typically appraised by what approach? A. Income approach. B. Gross rent multiplier approach. C. Option approach. D. Market data approach. Answer: D. Land is typically appraised by the market data approach by comparing the subject property to recent sales data of comparable parcels of land. Question 2. If Sarah Jean recently begins to receive her own tax bill after purchasing her property, this means she has most likely purchased into A. A condominium. B. A lease. C. A tenancy in common. D. A syndicate. Answer: A. A condominium is owned in fee simple, just as a normal home would be. This means that the homeowner, or condo owner, receives his or her own property tax bill. Question 3. Which party is most likely to sue for specific performance in regard to the purchase of real estate? A. The buyer. B. The seller. C. The broker. D. The attorney of the brokerage. Answer: A. The party most likely to sue for specific performance would be the buyer. This is done by the buyer to force the seller to sell. Question 4. When are mills most often used? A. In the calculation of square inches. B. In the appraisal of the property. C. In the assessment of the county fire code. D. In the assessment of property taxes. Answer: D. Mills, each 1/10 of a cent, are sometimes used to express the tax rate per dollar of assessed value. Question 5. What is the difference between market value of a property and the debt on the property including all liens? A. Income ratio. B. Assessed value. C. Equity. D. Market fluctuated value. Answer: C. Equity is the difference between the market value and the debt on the property. Question 6. The first step of a jurisdiction attempting to enact eminent domain is to A. Attempt to purchase the property in question. B. Give the owners a 30-day notice to vacate. C. Seek an injunction. D. Obtain a writ of closure. Answer: A. The first step of the jurisdiction would be to attempt to purchase the property at a fair market rate. Question 7. If the buyer, Sue, gives her agent, Jesse, an envelope of cash to hold as her earnest money for the property she wishes to buy, she is trusting that Jesse will protect this money for her and is an example of the fiduciary duty of A. Due process. B. Accounting. C. Competence. D. Escrow. Answer: B. This is the fiduciary duty of accounting. The agent must be able to hold and produce anything that is given to their care. Question 8. If a contract has a clause that states time is of the essence and either party fails to act in a timely manner to execute the contract, they can be held in A. Breach. B. Default. C. Void. D. Non-performance. Answer. B. If any party fails to take care of their matters in a timely manner in this situation could be held in default of contract. Question 9. In an area neighborhood that has a home in a dilapidated state that would require extensive remodeling to be compared to other homes in the area, what would this be an example of? A. Depreciation. B. Incurable depreciation. C. Curable depreciation. D. None of these. Answer. B. This is an external factor caused by the other homes in the area. This is a form of incurable depreciation. Question 10. The civil penalty for a first violation of the federal fair housing laws can be as much as A. $1,000. B. $5,000. C. $10,000. D. $50,000. Answer. D. The court may assess civil penalties against the violator up to $50,000 for a first violation and up to $100,000 for any subsequent violation. Question 1. If Steve J. Carlisle offers to purchase a house from the Jeffersons for $723,000 and a closing scheduled for August 7, and the Jeffersons sign a written acceptance with a provision that closing be executed on August 8, what can happen at this point now? A. Steve can back out of purchasing the house without a penalty. B. Steve can hold the Jeffersons to an August 7 closing. C. Steve can sue for specific performance on August 8. D. None of these. Answer. A. Since the Jeffersons made a counteroffer, it constitutes a rejection of the original offer. Therefore, Steve can either accept the new offer or reject it without penalty. Question 2. An agent knows a person that wishes to sell their existing property to purchase another more expensive property listed through another brokerage. What is the agency relationship to all parties involved? A. The known person is the agent's customer, no relationship exists between the seller of the more expensive property. B. The seller of the more expensive property is the client, the agent is in dual agency with both clients. C. The agent's known person is the client, the seller of the more expensive property is the customer. D. The agent is a dual agent to all parties. Answer. C. Under the laws of agency, in this particular situation, the known person is the client, and the seller of the other property is the customer of the agent. All parties are entitled to fair treatment. Question 3. Jeremy is a salesperson at a local real estate firm. He is required to submit to a dress code, attend meetings, and perform marketing tasks for the firm. He is paid in bi-weekly paychecks that have federal, state, and local taxes withheld. In this type of situation, the relationship with the firm is most likely that of A. An independent contractor. B. An employee. C. A contractor for hire. D. A manager. Answer. B. This type of situation that requires a person to perform tasks in a specific way for an organization is typical of an employer-employee relationship. Therefore, Jeremy is most likely an employee of the firm. Question 4. A violation of the Sherman Antitrust Act could be A. Competing brokers discussing fees and business practices. B. A broker discussing fees with an agent. C. An agent buying stock in the firm they are under contract with. D. None of these. Answer. A. Any discussion between competitors could be seen as an attempt to conspire to set the cost of real estate brokerage services, which is in violation of the Sherman Antitrust Act. Question 5. What happens if the principal is incapacitated or suffers death according to the laws of agency? A. Any contracts in place are cancelled. B. All dates are extended to allow time for processing. C. The agency is terminated. D. None of these. Answer. C. Upon death or incapacitation of a principal, the agency is terminated by operation of law. Question 6. What does a planned development consist of? A. Lots owned in common. B. Individual lots. C. Both individual lots and lots owned in common. D. None of these. Answer. C. A planned development includes both lots owned in common and lots owned individually. Question 7. If a home is located in an area that is zoned for commercial use, the home will have minimum value because of what principle? A. The principle of diminished returns. B. The principle of nonconformity. C. The principle of conformity. D. The principle of delegated zoning. Answer. C. The principle of conformity states that for a property to retain value, it should be in an area that consists of like-type properties. Question 8. If a tenant in a commercial building pays a rental fee that includes all property maintenance charges, utilities, and cleaning services, this type of lease is called A. Performance lease. B. Net lease. C. Pro rata lease. D. Gross lease. Answer. B. A net lease is one that includes rent and operating expenses in the rental price. Question 9. In appraising unique properties, which approach is best for determining value? A. B. Cost. C. Gross. D. Comparative. Answer. B. The cost approach is the preferred method when appraising unique properties. Question 10. Of the properties listed, which is considered the most unique and would use the cost approach method of appraisal? A. A piece of land. B. A condominium. C. A historic building. D. A farm. Answer. C. Of the answers given, a historical building is the most unique type of building and would therefore use the preferred appraisal method of the cost approach. Question 1. What special type of ownership is available in most non-community property states and is only available to married persons? A. Estate by escheat. B. Tenancy by the entirety. C. Dual tenancy. D. Coup estate. Answer. B. Tenancy by the entirety is available in most non-community property states and is automatically the assumed form of ownership when a couple purchases real estate together unless they opt for another form. Question 2. If a restaurant is located in a section of town that has been rezoned from restaurant and retail to commercial office building development, the restaurant can remain there by use of A. A special use permit. B. Non-conforming use. C. The grandfather use clause. D. Tenancy in specuity. Answer. B. The restaurant can remain in place by non-conforming use. The restaurant will not be able to expand into other neighboring sites, however. Question 3. A broker gives a written step-by-step instruction manual to new agents and instructs them to follow each of the steps exactly in order to produce sales for the brokerage. In addition, the broker threatens to discipline any agent that does not follow the steps, up to and including termination. The agent should A. Be scared of losing the position in the brokerage by means of firing. B. Follow the directions step by step. C. Do what they feel is best for obtaining results for the brokerage. An agent is an independent contractor and liable for results only, not the means they are achieved. D. None of these. Answer. C. A real estate agent working under a broker is liable to the company only for the results achieved as defined in the hiring contract and not by the specific means they are achieved. This is an independent contractor arrangement. If it were an employer-employee relationship, the employer can dictate the specific means of obtaining performance. Question 4. To match the specifications of a subject property, in the market data approach to appraisal, the sales prices of comparable properties are A. Increased. B. Decreased. C. Adjusted. D. Net zeroed. Answer. C. In the sales or market data approach to appraisal, the sales prices of comparable properties are adjusted to match the specifications of a subject property. Question 5. In real estate, the simplest form of property ownership is called A. Joint. B. Tenancy in common. C. Community. D. Severalty. Answer. D. The simplest form of ownership in regard to real estate is severalty because there is only one owner. All other forms include multiple party owners involved. Question 6. What is the formula for determining the value of an investment property? A. Net operating income divided by capitalization rate. B. Capitalization rate multiplied by net operating income. C. Potential gross income divided by operating income. D. Potential gross income divided by capitalization rate. Answer. A. Net operating income is divided by the capitalization rate to arrive at the value of the property. Question 7. If a buyer decides to pay for a property in cash, which form is required to be filed according to the IRS? A. Form 1090. B. Form 9600. C. Form 8300. D. Form 2740B. Answer. C. IRS Form 8300 must be filed on all cash payments that are $10,000 or more. Question 8. A cash payment of $10,001 is given as earnest money to secure a property. What must be filed? A. A documenting receipt. B. A procurement contract. C. An IRS Form 8300. D. An expediting loan form. Answer. C. The IRS requires any cash payments over $10,000 be recorded by filing a Form 8300. Question 9. A vendor vendee is a term that best describes the relationship between A. Purchase and sales. B. Mortgager mortgagee. C. Grantor grantee. D. Optioner optionee. Answer. A. The term vendor vendee is best matched with purchase and sales. Question 10. Which term is best related to lender borrower? A. Grantor grantee. B. Mortgager mortgagee. C. Optioner optionee. D. Seller buyer. Answer. B. The best match from this list that is related to lender borrower is mortgager mortgagee. This relationship is a lender borrower relationship. Question 1. At the close of the Civil War, a law that extended equal rights and real property to members of all races is called A. The Civil Property Amendment of 1866. B. The Property Rights Clause of 1868. C. The Civil Property Rights Act of 1865. D. The Civil Rights Act of 1866. Answer. D. The Civil Rights Act of 1866 is the law that granted equal rights in real property to all races in the United States. Question 2. The Civil Rights Act of 1866 prohibits discrimination in real estate based on A. Nationality and religious beliefs. B. Religious beliefs. C. Gender. D. Race. Answer. D. The Civil Rights Act of 1866 prohibits discrimination in real estate based on race. Question 3. A person with a child under the age of 18 is protected by the federal ban on discrimination based on familial status in order to A. Provide equal access to rentals. B. Allow for blockbusting to occur. C. Provide equal rights to families. D. Allow for a family to live in a tract neighborhood. Answer. A. The federal government provides protection from discrimination for people who have children that need places to live. This protects people from landlords that may try to not allow a person to rent or lease that has children. Question 4. An easement is defined as A. The legal right to pass over your neighbor's land. B. The right of way through your own property. C. The gradual easing away of land by water. D. None of these. Answer. A. An easement is the legal right to pass over another's land to get to your own or another's land. Question 5. The holder of a life estate may A. Maintain the property. B. Direct the disposition of the property at the end of the life estate. C. Renew agreements of the life estate in full. D. None of these. Answer. A. The holder of a life estate may maintain the property for the duration of the life estate. Usually the duration of a life estate is based on the life of an individual. Question 6. If Charles finds a home that is for sale by the owner and tells the owner that he will pay the full asking price and promises to send an earnest money check in the mail in the next 5 days, this contract is A. Valid. B. Void. C. Voidable. D. Unenforceable. Answer. D. According to the Statute of Frauds, all contracts for the sale of real estate must be in writing to be enforceable. Question 7. The value of an investment property, as estimated by an appraiser, the potential gross income does not include A. Settlements from the state government for losses due to eminent domain. B. Estimated rental income based on full occupancy. C. Fees related to parking and storage areas. D. None of these. Answer. A. Settlements or proceeds from the sale of land is not considered in the appraiser's valuation. Question 8. If Janice owns and occupies one side of a two-family house, and she wants to advertise the other side of the house as a non-smoking rental, can this be legally done without discriminating? A. Yes. The right to smoke is not protected by law. B. No. She cannot advertise discriminatory practices in regards to real estate. C. Yes. Since she is occupying part of the house herself, law provides for this protection. D. No. The only type of discrimination she can use is based on race. Answer. A. There is no law that protects a person's right to smoke. Advertising a rental as non-smoking is not discriminatory and is therefore legal. Question 9. When there is a conflict in limitations on the development of property, which rule applies? A. The least restrictive. B. The most restrictive. C. There is no rule to determine this. D. None of these. Answer. B. The most restrictive rule applies when there is a conflict in limitations on the development of property. This comes into play if there are zoning restrictions that conflict with architectural restrictions or deed restrictions. Question 10. If an appraiser was using the Consumer Price Index method to determine reproduction costs, this would be A. Reliable. B. Not reliable. C. Acceptable. D. Void. Answer. B. Reliable methods of determining reproduction costs are the square foot method, most common, cubic foot method, unit in place method, and quantity survey method. Question 1. Restrictive covenants included in deeds for all properties within a subdivision can dictate A. The architectural style of the structures. B. The ethnicity of prospective owners. C. The gender of future tenants. D. None of the above. Answer. A. Restrictive covenants cannot violate any existing laws, and are therefore illegal if they do. The ethnicity and gender of any prospective occupant is protected under federal law. A restrictive covenant can dictate the architectural style. Question 2. If Mary really wants to purchase John's house, and tells John's agent that she is willing to pay $560,000 for it instead of the list price of $540,000, John's agent should A. Not tell John because Mary told him not to offer that amount unless it is needed. B. Tell Mary that she will need to submit the proper paperwork for such an offer. C. Tell John. As John's agent, there is a duty of notice due to John and no confidentiality due to Mary. D. Take the listing off of the MLS. Answer. C. Even though Mary deserves honest and fair treatment, there is no duty entitled to Mary by John's agent. John's agent is bound by a duty of notice to John. Question 3. If a person dies that owns this type of estate, the ownership of that person automatically terminates. A. An estate in reversion. B. An accretion estate. C. A life estate. D. A lease pendens estate. Answer. C. Upon the death of a life tenant, the ownership in the life estate terminates. In addition, a life estate may be based on the lifespan of a third party. Question 4. In which of these circumstances is title to real property conveyed voluntarily? A. Eminent domain. B. Tax deed. C. A will. D. A certificate of title. Answer. C. A will is the only choice here that conveys title to real property voluntarily. The other choices, tax deed, certificate of title, and eminent domain convey titles to real property involuntarily. Question 5. A tenant looking to lease a property during a period of high inflation would most likely want to have a lease based on A. The cost of living index. B. The consumer price index. C. A tiered payment structure. D. A fixed rate. Answer. D. The tenant would most benefit from a lease that was based on a fixed rate during inflationary times. If the property manager based it on any of the other answers, the property manager could raise the rent as the market dictates. Question 6. As a buyer in a cooperative apartment, you will not receive A. A lease. B. Shares in the organization. C. A deed. D. None of these. Answer. C. A co-op apartment is personal property, not real property or real estate, and therefore no deed is given. Question 7. In order to have a legal and valid agency relationship, which of these is required? A. A valid real estate license. B. A passing of consideration. C. The passage of at least 48 hours. D. Mutual consent. Answer. D. Mutual consent is the only necessary option of the choices given to establish agency. The other choices are not part of the agency establishment. Question 8. A real estate agent should disclose any environmental hazards or conditions that could have an effect on the property, except in which case? A. When there is no need to disclose a hazard because the prospective buyers are from the area and already know what happens there. B. When there is a posted notice on the property. C. When another agent has already spoken to them about the environmental hazards of the property. D. None of the above. Answer, D. An agent has a liability to disclose any environmental conditions that could affect the property or the buyer's intended use. The safest bet is to always disclose, even if you think that you can get away with not doing so. Question 9. A contract for deed is best described as when A. Property purchased on an installment plan. B. A written contract for a future purchase transfer. C. An oral agreement in which the owner sells the property to a tenant for a negotiated installment price. D. None of these. Answer. A. The best answer is property purchased on an installment plan. However, this also would include the seller holding title to the property for at least 1 year after the date of sale. Question 10. In a loan closing, without the proper signature on the note, this is not created. A. Indebtedness. B. A deed. C. A contract. D. An estate. Answer. A. The signature on the note must be proper and valid to create the debt between the borrower and the lender. Question 1. The real estate commission for a property that is in probate is set by A. The real estate. B. The decedent. C. A court order. D. A probate officer. Answer. C. Commissions for property sold in probate are set by the individual court district. Question 2. The value of the best property in the neighborhood will be adversely affected by the presence of comparatively substandard property, is a statement relating to value and is known as the principle of A. Balance. B. Contribution. C. Regression. D. Progression. Answer. C. The principle of regression states that the worth of a greater valued property is reduced by the proximity of many lesser valued properties of the same type. Question 3. Which of the following types of lenders would have the greatest percentage of and the most funds invested in real estate mortgages? A. Savings and loan associations. B. Commercial banks. C. Life insurance companies. D. Mutual savings banks. Answer. A. Savings and loan associations place a greater percentage of their funds into real estate loans. These loans, namely, are in the single-family dwelling area. As to life insurance companies, they prefer long-term, high-valued commercial properties. Commercial banks, due to the liquidity requirements, prefer short-term loans such as construction loans, although here too, funds are available for the home loan market. Question 4. In addition to land resulting in the formation of a gradual buildup by natural causes, the party who would benefit from this would be A. The landowner. B. The local government. C. The federal government. D. The landowner's neighbor. Answer. A. The question describes accretion, and the land that accretes from a river belongs to the adjoining landowner. Question 5. No prudent person would pay more for a parcel of real property than the price of a reasonably close alternative, which is available without undue delay, refers mass nearly to the principle of A. Balance. B. Conformity. C. Substitution. D. Intervention. Answer. C. The principle of substitution, in essence, states that no prudent person would pay more for a parcel of real property than the price of a reasonably close alternative which is available without undue delay. Question 6. Sam inherited rolling hills from his uncle. The first thing he did with the vacant property was to remove all the topsoil, which he sold to a landscaping company. Sam then removed a thick layer of limestone and sold it to a construction company. Finally, he dug 40 feet into the bedrock and sold it for gravel. When Sam died, he left rolling hills to his daughter, Pat. Which of the following statements is true? A. Pat inherits nothing, because rolling hills no longer exists. B. Pat inherits a large hole in the ground, but it is still rolling hills, down to the center of the earth. C. Pat owns the gravel, limestone, and topsoil, no matter where it is. D. Sam's estate must restore rolling hills to its original condition. Answer. B. Pat inherits exactly what Sam owned just before his death, a location on the earth's surface, everything below it to the center of the earth and the space above it toward the heavens. Question 7. A true statement regarding floor waters is that flood waters A. Refer to water in minor depths, either standing or flowing, which do not produce serious surface scour or leave deposits of silt. B. Refer to water on the surface of the land but lower than the water table in the area. C. Are deemed the enemy of every affected owner, and owner may protect their property by employment any reasonable protective measures. D. Are found below the water table, at the water table, and above the water table. Answer. C. Flood waters, water from a downpour, river overflowing its bank. One may protect himself against such flood by building a dike, or sandbagging, or other methods of diverting the water to other property owners. Question 8. Single-family home values are least protected in neighborhoods where there is A. A similarity of income of the owners. B. A predominance of residents belonging to the same ethnic or religious group affiliation. C. A minimum of change to existing restrictions as a result of legal restrictions. D. An increasing mixture of average quality homes with high quality homes. Answer. D. In an area where average quality homes are being constructed among high quality homes, there would tend to be a decrease in the overall neighborhood property values. Question 9. The primary justification for zoning ordinances is that they A. Promote conformity in the outward appearances of structures. B. Limit the supply of specific businesses within a zoned area. C. Promote the general health, safety, and welfare of the community. D. Increase the tax base of the local governing body. Answer. C. One of the requirements before a zoning ordinance is considered lawful is that it promotes the general health, safety, and welfare of the community. Question 10. Which of the following actions or events would result in the termination of a sales escrow? A. Revocation of the escrow instructions by the broker of the seller. B. The cancellation of the escrow by either party. C. The mutual consent of the parties. D. The death of either of the parties. Answer. C. Escrow instructions are an agreement between buyer and seller, and cannot be unilaterally cancelled without the consent of the other. Death would not terminate their agreement, but the instructions would be a contract normally binding upon the heirs. Escrow can be terminated by the mutual consent of the parties. Question 1. Under FHA standards, the minimum ceiling height for a single-family residential construction is A. 7.5 feet, B. 8 feet, C. 8.5 feet, D. 9 feet. Answer. A. Although most ceiling heights are 8 feet, the FHA minimum requirement is 7.5 feet. Question 2. Real estate assets are usually acquired by using A. The results of long-term and short-term gains, B. The supply and demand of equity capital, C. Equity funds and money market funds, D. Debt funds and equity funds. Answer. D. There are mutual funds and real estate investment trusts that do acquire real estate assets, either debt assets, mortgage assets, or equity assets, ownership assets. Question 3. From a historical standpoint, the major function, objective and aim of the FHA program has been provided by A. Title I, B. Title II, C. Title III, D. Title IV. Answer. B. The largest and most important activity of FHA is the insurance, under Title II, of mortgages for home purchase and construction. Question 4. Examples of negotiable instruments are as follows, except A. A mortgage secured by a promissory note, B. A draft, C. A check, D. An installment note. Answer. A. The note is negotiable but not the mortgage. Question 5. A form that is usually prepared to allow a real estate licensee to act as an agent for all principal parties to the transaction involved is A. An agreement of sale, B. An exchange agreement, C. A loan broker's statement, D. A real property security statement. Answer. B. Under an exchange agreement, the real estate licensee acts for both parties. This is one instance where he could earn a commission from each party to the transaction. Question 6. The hiring of a specialist in property management would be justified by A. Absentee ownership, B. Technological advances in building concepts, C. Vacancy factor higher than normal, D. Urbanization. Answer. A. In absentee ownership, the owner lives away from the property and is not able to adequately supervise it. Question 7. Which of the following is not one of the four important elements of value? A. Scarcity, B. Appreciation, C. Utility, D. Transferability. Answer. B. The four elements of value are utility, scarcity, demand, and transferability. Question 8. Madison is a mortgage loan broker. When setting up a loan, Madison differs from Carter, a mortgage banker, in which of the following ways? A. Carter is authorized by law to make larger loans than Madison. B. Madison is exempt from the Finance Code. C. Madison does not normally use his own funds in arranging a loan. D. Carter deals primarily in loans which must be recorded. Madison's loans are normally not recorded. Answer. C. A mortgage loan broker normally does not loan his own funds, but negotiates the placement or sale of a loan with a particular lender. A mortgage banker generally has the funds with which to make a loan. Question 9. The following are correct statements concerning an option, except A. The optioner must perform if the optionee exercises his option within the period specified. B. The optionee must perform if the optioner exercises his option within the period specified. C. To exercise the option, the buyer must pay the amount specified in the option. D. The consideration for granting the option must be actual. Answer B. The question is a negative question asking for a false statement concerning options. Answer 2 states, the optionee must perform, which is false. The optionee receives and the optioner must perform. The optionee is the one who exercises the option. Answers 1, 3, and 4 are all correct. Regarding answer 2, there must be some consideration. It may be money or an act. In a lease option, it often states that there is the option to purchase the property for $100,000. The consideration is the leasing of the property. The leasing of the property is sufficient consideration upon the part of the optionee. An option must contain all the terms of the purchase similar to a deposit receipt. At the time of exercise, all that the optionee must do is state, I will buy according to the option terms. Question 10. The provision that states the realtor shall not publicly disparage the business practice of a competitor appears in the A. Real estate law. B. Commissioner's rules and regulations. C. NAR Code of Ethics. D. Business and Professions Codes. Answer C. This provision appears in the National Association of Realtors Code of Ethics.
Exam Scholar, Real Estate Edition.